EU settlement scheme and relationship breakdown. If you have been in the UK and you have a family member visa under the EU settlement scheme, let's say you are married to a European national, that European national has been living in the UK, either has pre-settled status, settled status, or even got British citizenship. But as an EU national, they have the right to live in the UK, and you have got pre-settled status as a family member, as a wife or husband of that particular person. In that case, if a relationship breakdown happens, so this is usually the process that happens. I will explain the process and what can be done or what is possible. I will get into that. So firstly, there is a home office page where the other partner, the sponsor in your case, the person who has the EU national passport, reports to the home office through that UK home office page. If you Google search for it, it will come up relationship breakdown reporting to UKVI or home office, and that page should come out. So that's how they are required to report, because they were the sponsors. And once they report, this is how usually the process goes is, uh, it goes to, there is a status review team that sits internally within home office. uh, these are the three possible scenarios that might happen once they receive such a notification. So whichever team it goes to first, one notification definitely goes to a status review team, and they may consider one of these options. So I'll just run through those. So spouses divorce cases, I've just noted down some things. So if they think that you no longer meet the requirements to qualify for your current visa, that is your spouse visa, partner visa, whatever you call it, so on the basis of the relationship to that EU national, European Union, EEA national or EU national, if they think that you no longer meet the requirements, then they have the option that these are three different options that they will check whether you do meet the requirements. Then they would just write, note it on the file, or they may write to you saying we have reviewed and you meet the requirements. So that is what they may happen. Or they may just make a recording. So don't expect from home office, they are not particular in just informing clients, unless they want to curtail some things. So if either they may just record on the system saying we have reviewed the status and it is fine, we think that this person can continue living on their own status. Second option, they may send you a notification saying that yes, you have reviewed the status and you still meet the requirements. These are two good options or positive options in your favor. However, the third option, which usually would happen if a relationship breakdown happens, so as per the European Union EEA regulations that were before Brexit and the current EUSS, the basis of a family member, has a spouse living with a EU national, is that they should have been married for at least 3 years if you want to qualify something in your own right. If they see that the marriage has existed at least for 3 years, and at least for out of that 1 year both of you have lived together inside the UK, then you would have the retention of rights, retained rights. Under that you would qualify. So I think that is what they would usually check. If you do qualify for retained right status, they may not bother you. They will, whatever evidence they have, they will just record it on the file. But if they feel that you are not meeting those requirements and there is no possibility of retention of rights, for example, you just entered the UK, you have just got married, let's say 2 years back, and so one of the requirements that you're not meeting for the retention of rights is you have not been married for 3 years. Let's say that is, I'm just taking an example. And after that, the notification happens, it goes to the status review team. They check the situation, look at the documentation, evidence, whatever they have on file on your case from your applications, previous applications. They will send you a letter, minded to curtail. So it is called as minded to curtail. We may curtail, and they would give you 14 days period, ask for, and they would ask you to send some evidence. So whatever is your right, you may have to send cohabitation evidence, etc. But if you don't meet the requirements, remember that this is something that the team will definitely consider, which is because they cannot just go and curtail the visa one-sidedly just on the reporting on the EU settlement scheme. On other areas they can do it. British immigration rules works differently, but under the EU settlement scheme, if the relationship breakdown has happened, they think that you may not qualify under the retention of rights or any other right for that matter. They may send you a letter asking you to provide some more evidence to show that you still qualify for that particular let's say pre-settled status is something that you may have definitely, so you still continue to have the pre-settled status. So this is something, if that is something that you have received, then definitely take immigration advice from lawyers, get your documents reviewed, get your status reviewed, see if there is any other application that you can make under the settlement scheme or under the British immigration rules. Definitely get it tested. If you have received such a letter minded to curtail, where they say we will curtail you, we may curtail your leave, cancel your leave, so curtailment word is gone, so we may cancel your leave, and they're giving you an opportunity to provide evidence, documents, information of why you say that they should not cancel your leave. So in that case, usually lawyers, if that is the case and 14 days is less time, we can ask for more time. Usually that's the first approach. We try to ask for more time, and then we try to assess if 14 days is not enough time to gather all the documentation and evidence. So usually home office does agree with that. They will usually give it to us. But one of this is very important thing I wanted to cover this point, where people have received that email informing that their permission may be curtailed. So please take it seriously. Reply to it yourself with any evidence you have. Usually, when they send that, they have checked most of the things, and they are of the opinion that you don't have any status. You cannot continue to hold. They think that you do not meet the requirements of the scheme to continue to hold that status. So definitely take immigration advice in such cases. Even if on the other side, let's say you don't receive that curtailment or minded to curtail email or any notification, even if there is a relationship breakdown, definitely seek advice from immigration lawyers as soon as possible. I have seen people assume that they have status, but then when they go to apply for settled status or something, or try to extend it, now I know there are, yeah, automatic extensions are happening, but for definitely for family members it doesn't happen, because the relationship side is not tested. They cannot check that automatically. So if you are in a situation where your relationship has broken down and the partner has reported you, or at least if the relationship has broken down, definitely speak to immigration lawyers, take exhaustive advice, and decide on all your options. You may have retained rights, but then in that case also, you should ideally upgrade your visa, or if you don't, kind of not upgrade, change your status from a family member of a EU national to a retained rights holder on the basis of past relationship to an EU national. So, because that is one thing that I've observed. These are some things that we have seen over a period of time with clients and experience other lawyers with home office discussions and all. So, overall, these are the pain points or concerns where clients are held. One of the things is they don't change their status from EU national, family member of an EU national, to a retained rights holder. In that case, if they try to enter and the home office is aware that the relationship is no longer subsisting, the immigration officer may not allow you to enter the UK because you have not updated it. They don't know whether you have retained rights, and they may not assess it at that port of entry, airport, seaport, however you are coming in the UK. So that is another point. So anytime a relationship breakdown happens, if you are married to a national and your status is based on that, then definitely take proper immigration advice. You can book a paid consultation with us, and we can also analyze your case and tell you your options. And if you want any legal representation, we also do that. So thank you very much.